بنی آدم اعضای یکدیگرند که در آفرینش ز یک گوهرند. Hope to have a good day. Our topic is about international challenges of children's rights. Responsible author Irfan Futuhi, the second author Kimia Sadat Mirbozorgi, the third author Reyhane Sarhaddi Shomali. Children's rights are one of the most important examples of human rights because children are one of the most important members of a society for two reasons. Number one, the thoughts of children and their education and training shape their future, which affects the society. Number two, for the reason children are weak creatures due to underdevelopment and need physical and psychological support and care, which is the reason why war and violence leave irreparable and harmful effects on the psyche of children. The meaning of interpretation of children's rights. Allowing the capacity of children's rights to have the authority to act, which includes physical, mental, and emotional actions, and prohibit any mistreatment of children. The Convention on the Rights of the Child is the most important international legal document that tries to consider the child as a member of a family and society, and the rights are considered for it, such as the creation of educational association that are provided in terms of secrecy and are immune from abuse and sexual exploitation. Children's criminal court, not publicity of criminal proceeding. Due to the vulnerability of the character of the accused child and teenager in order to avoid labeling and institutionalization of delinquency in him, it is believed that the proceedings should not be public, and this case is one of the exceptions in the proceedings because the child is the presence of the media and public. He became anxious and did not lose his ability explain to the situation. The publication of the proceedings and making them available to the public will be based on the principle of anonymity. Avoid labeling. This theory is based on thinking and view of other towards a person, and it causes self-confidence to be taken away, and criminal self-concept is formed in them, and it leads to deviance and therefore creates challenges in the future, such as a job and educational opportunity. Convention on the Rights of Child without distinguishing between a child and a teenager, a child up the age of 18. Article 1 of this treaty stipulates a child in this treaty means a person under 18 years of age, unless the age of majority is determined to be lower according to the applicable domestic law, the age of persons and criminal responsibility are determined by the government's observance of private rights. When the child enters the hearing and knows that his testimony and defense will be heard by activists, he cannot raise some of his content and defense due to shame and fear, and his freedom is denied. Attention to the principle of innocence. The principle of acquittal is a guarantee for the accused in front of the actors of the criminal process, as well as the public opinion, in order to prevent the person from being recognized as guilty before the trial and proving the crime. He will be entitled to the following. Number 1, as long as his crime is not proven according to the law and by issuing a definitive verdict, he will be pronounced innocent. Therefore, any action that directly or indirectly, explicitly or implicitly leads to the creation of a mentally regarding the guilt of the accused person is considered as a violation of a principle of innocence. One of the most important judicial and regulatory human rights issues is the issues of non-public hearings. Non-publicity of children's and teenagers' proceedings is human rights procedure. Hearing in the Inter-European Court of Human Rights located in France and the Inter-American Court of Human Rights located in Costa Rica. These two institutions are decisive institutions in the field of human rights in related cases. Inter-European Court of Human Rights. Although the European Convention on Human Rights has not considered a criterion for determining the age of children and adolescents and their criminal responsibility, according to the studies, they decided not to consider the age of the accused too low. In the European Court of Human Rights, which was filed against England, the petitioners stated that two 11-year-old boys were charged with the kidnapping and horrific murder of a 2-year-old child. Their trial in the court was public and full of the reporters, and it was held in the manner of adult proceedings, hence the claim of violation. Article 6, paragraph 1, fair trial due to non-public holding of proceedings, and Article 3, humanitarian behavior towards the accused, one of the accused who could not defend himself well, stated that when the public came to the courtroom, he was shocked and it has been mocked and caused the child to cry. In addition, the identities of the person were published in the media and the defendants were worried that they would not be seen as criminals. Inter-American Court of Human Rights. Unlike the European Court, this court has considered the age of maturity to be 18 years, which means that people under the age of 18 should be treated according to the law of children and adolescents. This court has determined the scopes and competence of the rights to a fair hearing for children and teenagers and has clearly mentioned the non-public holding of the proceedings. Child Rights Committee. The Committee on the Rights of the Child is established as a monitoring body in line with the implementation of provisions of the Convention on the Rights of the Child and the compliments that are made against countries regarding the non-implementation of the provision of the Convention on the Rights of the Child are submitted. The Committee on the Rights of the Child, international civil and political rights, and complying with its Article 14, paragraph 1, and also referring to the rights to privacy contained in Article 6, paragraph 4 of the Convention on the Rights of the Child, has introduced the necessity of interests of children and adolescents as one of the legal exceptions to the principle of public protection. In today's world, human rights and international law regarding the killing of civilians, especially women and children, are very important. The prohibition of violence against civilians, including women and children, is a principle of customary international law applicable in all situations of armed conflict. Humanitarian principle of distinction and proportionality require belligerents to distinguish between combatants and civilians and prohibit civilian harm beyond military boundaries. Due to changing nature of war, this principle is eroding among armed forces and groups, and women and children are often killed or injured during military operations. In this situation, two basic questions are raised. What is the action and performance of human rights and international law in relation to the systematically of human rights? How are the tools of applying human rights laws and international laws implemented? Security Council Resolution 1882 identified patterns of killing and maiming of children contrary to international law as a target for inclusion in Secretary General's report on children and armed conflict. Reducing frequency and intensity of armed conflicts is an explicit goal and a common theme of the 2030 Sustainable Development Goals. The international law of armed conflict, which is a part of humanitarian law, was compiled much earlier than the international law of human rights. Important steps in the development of the humanitarian law of armed conflict include the Diplomatic Conference of Paris 1856, Geneva 1864, Petersburg 1868, Brussels 1874, The Hague 1899, and 907. The international law documents approved in these conferences form the basis of modern human rights and armed conflicts, the most relevant of which are the four Geneva Conventions 1949 and their two additional protocols 1977. In human rights, one of the most important humanitarian principles governing war is the principle of separation or distinction, based on which a distinction must be made between the civilian and the military population, and that people and the civilian population should not be attacked. This principle is recognized in the Fourth Geneva Convention relating to the protection of civilian persons in the time of war and includes women and children. Consequently, the world today needs to enact laws to protect women and children in times of war. But the question is to what extent these laws can be implemented in different countries. To answer this question, you should pay attention to the guarantee of its implementation in the condition of military war. It is possible to create a shelter for women and children outside the war-off zone by creating a safe shelter and using suitable materials.